I hope that I can contribute to these great discussions, right, by telling you a bit about the current state of platform regulation talks in Brazil. We have a proposal under discussion since last year. And, oh, sorry. So in the next 20 minutes, I'd like to tell you a little bit about these proposals. That might get a bit descriptive, but I also would like to make some points. Some of them I'm still thinking about, I'm still developing, so it'll be nice to try them on with this audience today. So they're basically the following. In first place, the normative, I want to tell you about the normative framework that currently applies, despite of these proposals. They are still proposals after all. How I believe they relate to what happened in the 2018 presidential elections. I want to tell you a little bit about the biggest platform regulation dilemmas that they tackle, and to which degree they relate to global debates and to the country's own tradition of internet regulation. First, I'd like to clarify that there is no such thing as before and after disinformation. As it is everywhere, disinformation has been a default of our democracy, and I'm illustrating this here today by showing you this picture of the 1989 presidential debate. These were the first direct elections Brazil had after the military dictatorship. And the day before the second and final round of the elections, the biggest broadcaster, the monopolistic broadcaster, aired a version of the debate between the two candidates that was edited in order to highlight one of the candidates' best moments and the worst moments of the other candidate. And as you know, not necessarily, but the candidate that was favored by the edition won the elections. And this is just illustration for you of how manipulation of information for political purposes is nothing new. So it is not a lightning that struck us once and changed everything. But what I would like to show you today is that after the 2018 elections, where there was an actual digital disinformation campaign put in place, as it has already been reported by the press and also by the specialized literature, this debate grew. And in my personal view, it contributed to the narrative that drove the proposals for platform regulation last year. So very quickly, what happened in 2018 is that during the presidential elections campaign, the winning campaign, the current President Jair Bolsonaro employed micro-targeting techniques to disseminate political marketing and false information, mostly through WhatsApp, fueled by questionable use of data. And I use the word questionable here because by then Brazil did not have yet a data protection legislation in force. So even though purpose limitation and legitimate interest principles could apply, this is still arguable. What happened was basically that they used the software that harvested phone numbers from Facebook from users that had pointed out their phone numbers to be public information, right? So this whole use is at the very least questionable. And the context in which this happened is of a political crisis that traced back to 2013, when a scenario of economic crisis and popular dissatisfaction triggered off a series of events that relates to different degrees to the political context that we still experience nowadays. And disinformation experience during democratic procedures in other countries, notably Brexit and the US 2016 presidential elections. So the normative framework that applied then, and that still applies now, is influenced by different legal instruments, but mostly by the Marco Civil, which is also internationally known as the Brazil Internet Civil Rights Framework or the Brazil's Internet Bill of Rights. So some of you might have heard of it already. This was a long debated and 2014 approved law that establishes the principles, guarantees, and duties for use of the internet in the Brazilian territory. It has, for its most part, the form of a Bill of Rights. That rules on subjects like net neutrality, protection of private communications, and the country's intermediary liability system. So the liability room that is provided here is a courts-based one. meaning that platforms can only be liable for user infringement if there is a judicial decision in this sense. So while this is often referred to be a best practice for intermediary liability, it has also its own limitations, especially with regard to broader policy contexts as it is internet governance. Also, when trying to answer some of the questions regarding platform regulation, the literature often turns to a country's freedom of expression tradition and how its rationality is transferred or not transferred to digital communications. This is very clear in the US and in Europe, in my opinion, which have distinguished traditions on how to regulate or not regulate speech, and that also centralize most of the academic debates. In Brazil, what we have is a past of institutionalized censorship during the military dictatorship. There was actually a government authority responsible for judging, adjudicating on what could or could not be published prior to publication. We have a presence of unenforced communications regulation in the sense that even though the Constitution provides for the protection of freedom of expression as a collective right, these regulations never really made it through the concentration of political powers that has always marked the media market. Also, we see what I identify as a pseudo-libertarian approach, in the sense that abuses to freedom of expression are to be adjudicated by the judiciary. But you still cannot really identify a tradition when you look at the jurisprudence, because there's a lot of even contradictory understandings on the scope of freedom of speech. And also a series of other practices like the use of judicial actions to intimidate journalists, to intimidate publications about people that are in the public interest. So it is hard to put our finger on exactly what distinguishes that tradition and should or should not be transferred to online communications. But this question is not as relevant here as it is in other contexts, but I will come back to that soon. So until March 2020, the legislation that was proposed after the 2018 elections was mostly focused on individual criminal liability. So these were proposals that created new criminal types or that enhanced already existing sanctions for libel and defamation when they were committed in the realm of disinformation campaigns or related to disinformation somehow. The new proposals started arriving in March 2020, about a year ago, and they brought a mix of regulatory strategies to this debate, encompassing what I call structural regulation. That is the regulation aimed at platforms' business models rather than at individuals or at data specifically. This is to a relevant degree, in my opinion, synced with international debates on platform regulation. We have European literature already identifying a shift from liability to responsibility or from liability to duty, in the similar sense of taking it away from individuals and pointing it at platforms. And I think we can also say that they were partially inspired by the NetzDG and other foreign legislation that have been under discussion in the last years. So currently, the debates are focused on one proposal. There were several different ones in the beginning, and now they are focused on proposal 2630 from 2020. And they merged a lot of different regulatory strategies tackling different aspects of platform regulation. I brought what I believe to be the most important and delicate ones here to talk to you about today. The first one are a few obligations regarding civil registration and identification, in the sense that in order to have a profile or an account in a social media platform, individuals would have to provide their identification documents, which clearly raises some concerns regarding the needs for anonymity and protection of other fundamental rights. There are a series of provisions targeting private messaging apps, and here we see a clear influence of the techniques that were employed in 2018. Regulation of WhatsApp and the likes has been pushed throughout this process. And this includes, for instance, providing hypotheses for account suspension, forwarding limits, prohibition of using external softwares, and a very controversial obligation to store metadata on all communications in order to be able to trace and identify messages that reached 1,000 or more people in 2 weeks' time. So this one in particular has moved a lot of debate. Specialists and politicians that defend this kind of measure say that they are trying to draw a line on where private communication becomes mass communication and therefore inspires more regulation. This, of course, generates a series of risks to privacy. And there has been signals that this proposal will not stand. But this is yet to be seen. These discussions are ongoing. In fact, we even have a bit of insecurity regarding which text of the proposal to consider, because officially these provisions are still there, but there's already another unofficial text circulating since last year, but we haven't seen it being actually adopted and formalized yet. So everything is still pretty much on the table. And since these debates were resumed last week, we are about to see where they are going, in which direction they're going next. Also, there are a few provisions on due process regarding content moderation, some removal obligations in the face of user notification. This does affect the current liability system. In some degree, these proposals are welcoming in the sense of assuring that the other parts is notified, enhancing due process and transparency. These obligations are, however, not necessary in a few cases where that content is clearly illegal. And then here we have the ever-present issue of delegating law enforcement to a private actor, that is to say what's illegal and what is not. There are all sorts of transparency obligations, which I am sure many of you are familiar with by now. The proposal would demand platforms to inform on how much content is notified, how much is actually taken down, in which time, advertising information, political advertisement information, who's financing what kind of message, and etc. There are some provisions regarding public interest social network accounts, and this is very marked by the fact that some elected politicians notably use their accounts to communicate with their electorate, to communicate about their mandate, and they still block people, they block journalists and even other representatives. So there is a series of proposals in this sense to of course, regarding the accounts of politicians that actually use the accounts to communicate with the general public, so personal use would not be under this obligation. And there is also a whole institutional arrangement being proposed called regulated self-regulation. And I think you can feel already from my reaction how I do not welcome this one so much. It's not that I do not welcome the idea of regulated self-regulation by itself. I just think it's being proposed here very much inspired by what is in the DSA currently, I think. But what is in the DSA hasn't really worked out so well here, as far as I know, here in Germany. There is a transparency council being proposed. There is a self-regulatory body being proposed, but it's still very uncertain what each one of these bodies would be doing, and the requirement for representation of platforms in the councils that will be responsible for enforcing legislation towards these platforms is something that I find at least puzzling. So there's a lot to be said really about each one of these strategies that are being considered under proposal 2630. And there's no single assessment to all of them. But there are at least 4 takeaways that can inform our discussions on platform regulation, and ultimately on what the role of the states is in this context. And these are my 4 takeaways. This will be my last slide, and then I'll be ready to talk to you, which I'm looking forward to. So my first takeaway, and here I promised Tricia I'd make the disclaimer that some of these ideas I'm still trying out, but not all of them. The first one, not so much. So the debates in Brazil are certainly included in a global context, right? And some of the strategies under discussion are familiar to other debates that are happening in other countries. But before we assume influence or import from one country to another, I would like to invite you into another perspective, which is that Brazil has its own tradition of internet regulation. Around the same time that the US was discussing SOPA PIPA legislation, Brazil was discussing similar bills of law in its own context. They were called Lei Azeredo at the time. And even in their limitations, in their targeting of individual behavior and etc., they were similar to SOPA PIPA. But these discussions laid ground for what later became the Marco Civil. Right, and the Marco Civil was approved in 2014 as the first national diploma that institutionalized a Bill of Rights for the internet. So this diploma proved beneficial in a lot of senses, but also limited in several others. So a next step in this history became necessary. And I think this is also where the current proposals stand. This is to tell you that they cannot be reduced to foreign import to the US or Europe or whatever, importing their own tradition, but also as a country's own tradition of history of internet regulation. And of course, there is some influence, as you can see in the provisions of the NET-CDG that inspired some provisions in this proposal. But no more than there is in any other place that is discussing the same issues right now, and that tends to look outside and see what else is going on, right? So for this reason, the question regarding regulation of freedom of expression here is not as determinant as it is in other legal contexts, because this tradition of internet regulation has at the same time been influenced by the way that Brazil deals with speech and communications, sure, to a certain degree, right? It's still the same country, the same institutions, the same problems, but at the same time, this history of internet regulation has run in parallel to the freedom of expression one. So this is a question that has to be considered in a different degree when we are talking about this specific tradition here. In second place, despite disinformation fueling these debates as justification and as a great part of the narratives that have been driving these proposals, what we see today is not fit to disinformation specifically at all. It has clearly a broad scope of regulating digital platforms. The name proposed for the law is the Law for Responsibility, Liberty, and Transparency Online. And while this is welcome, we also need more consistency on policy justifications and policy proposals, if not for coherence, but for the sake of making sure that what is being proposed will actually be efficient or feasible or meet, right, the justifications that are driving it. Third place, these debates also showed us a shift from techniques focused on individual liability to platforms, right? Platforms business models. But this does not necessarily minimize risks for users' fundamental rights violations, because as I showed you a little bit from the proposals in my previous slides, there are already a lot of incentives being created that jeopardize privacy, that jeopardize freedom of expression, and that don't answer key issues with the way that platforms exercise their activities nowadays. Like, for instance, when I told you about the delegation of speech enforcement, of telling what kind of speech is legal and what is not. So this brings me to my last point, which is that I absolutely believe this is a conversation that is necessary and take it further. But I also feel like we need to keep in mind that these measures that are on the table only challenge the status quo to a certain degree. They are still carved within the current power imbalances. And if this is the choice that we're making, if this is intentional, that's fine. But then we need to be aware that whatever results they deliver will also be limited by these power imbalances. So we might not land as far as we think we will land after all, either in Brazil or in Europe or in the US or in so many other contexts that are taking the time to debate platform regulation at this point. So I hope this was helpful, and I really look forward to hearing your questions.